listener production.
April 1656. A ship is wrecked off the coast of Western Australia. Its cargo sank with it. Many of those on board perished in the tragedy. Who owns what remains on board the ship at the bottom of the ocean? Back in the 1970s, one man decided to find out. I'm Dan Mullins. This is Crime Insider's Judgment, a deep dive on a judge's final verdict of a crime and what transpired to incite that judgment. The High Court of Australia considered Robinson versus Western Australian Museum in 1977. This isn't just a dry legal dispute. It's a story that intertwines maritime adventure, colonial shipwrecks, and big questions about who owns the treasures of the sea. The case centers on Alan Robinson, a diver who discovered a 17th century Dutch shipwreck off the Western Australian coast and fought for his rights to salvage it against state legislation that claimed ownership for the public museum. Why does this matter? It highlights tensions between individual rights, state powers, and Commonwealth authority in Australia, especially over offshore resources. Decided by the High Court in 1977, it influenced how we protect historic wrecks today. To fully grasp Robinson versus Western Australian Museum, we need to step into the 17th century world of maritime exploration and colonial ambition. The Vergulde Draak, or Gilded Dragon, was a vessel of the Dutch East India Company known as the VOC, one of the most powerful commercial enterprises in history. Founded in the year 1602, the VOC was a proto-corporation with a monopoly on Dutch trade in Asia, controlling vast fleets, armies, and colonies. It was created by merging several smaller competing trading companies into one powerful monopoly over Dutch trade with Asia. The VOC is often considered the world's first multinational corporation and also the first company to issue shares of stock to the public. It was a key player in the global spice trade, shipping nutmeg, cloves, and pepper from the East Indies in modern Indonesia to Europe, where such goods were worth more than gold. The VOC's ships, like the Vergulde Draak, were lifelines of wealth and power, but their voyages were perilous, navigating uncharted waters with rudimentary maps and constant threats of storms, reefs, and piracy. The Vergulde Draak was a 42-metre, 260-ton float, a sleek, efficient ship designed for cargo, not combat, launched in 1653. On its maiden voyage from Texel in the Netherlands to Batavia, which is now Jakarta, it carried 193 crew, passengers, and a precious cargo, over 78,600 guilders in silver coins, equivalent to millions today, plus trade goods like cloth, wine, and supplies for VOC outposts. This was no ordinary ship. It was a floating vault, symbolizing Dutch wealth and ambition in a world where European powers were racing to dominate global trade. On April 28, 1656, disaster struck. Sailing along the uncharted Western Australian coast, then known as the Southland, the ship hit a reef near Ledge Point, about 100 kilometres north of modern Perth. The coast was notorious for its shallow reefs and fierce currents, and the VOC's navigational tools, reliant on dead reckoning and imprecise charts, were no match. The Vergulde Draak broke apart, scattering its treasures across the seabed. Of the 193 aboard, only 75 reached shore. These survivors faced a brutal ordeal: no food, little water, and an unfamiliar land inhabited by indigenous peoples whose languages and customs were unknown to them. They likely perished from exposure, starvation, conflict with local people, or attempting to leave. The fate of those survivors has become part of Australia's enduring maritime mysteries. In a desperate bid for rescue, 7 men built a makeshift boat from wreckage and sailed 2,900 kilometres to Batavia, arriving 41 days later. They raised the alarm. The VOC dispatched rescue missions in 1656 and 1658, but miscalculated coordinates and stormy seas meant they found neither survivors nor the wreck. The 68 left behind vanished. Some speculate they perished, while others suggest possible integration with local indigenous groups, hinted at by later archaeological finds of European objects in Aboriginal sites. This tragedy wasn't unique. The Western Australian coast, dubbed the Shipwreck Coast, claimed several VOC ships, the Batavia in 1629, the Zutdorp in 1712, and the Zeewick in 1727. These wrecks, lying beyond the low water mark in territorial waters, held not just economic value, but cultural significance, as they represented early European contact with Australia, predating British colonisation by over a century. For Indigenous peoples, these encounters may have introduced new materials or stories, though oral histories are sparse. Fast forward to 1963. Alan Robinson, a diver and amateur historian, became obsessed with finding the Vergulda Draak. Using VOC archives, old maps, and local knowledge, he pinpointed the wreck in shallow waters off Ledge Point. But there's a twist to this story. 16-year-old Graham Anderson was out spearfishing when he spotted elephant tusks on the ocean floor. He was on a day trip with his father and Alan Robinson. While Henderson discovered the wreck, it was Robinson who claimed it. Graham Henderson ended up heavily involved in Western Australian maritime history, ending up at one stage as senior curator and director of the WA Maritime Museum. Back to 1963. The discovery was a sensation. Thousands of silver coins, cannons, pottery, and personal items like pipes and buttons emerged from the sea, offering a tangible link to the 17th century. There were daily newspaper articles. But this wasn't just about treasure. The find sparked public fascination with Australia's pre-colonial history and raised questions about who should control such relics, the individual who risked life and resources to find them, or the state, tasked with preserving heritage for all. Robinson's salvage efforts set the stage for a legal battle that would reshape Australian maritime law. Robinson wasn't working in a legal vacuum. As a responsible salver, he notified the Commonwealth Receiver of Wrecks in 1957 and again in 1963, staking a claim under the Federal Navigation Act of 1912, which governed salvage and entitled finders to rewards for recovering wrecks. He submitted some artefacts to the receiver and others to the Western Australian Museum Board, expecting recognition or compensation for his efforts, which cost him significant time and money. But here's where the plot thickens. Western Australia had its own plans for historic wrecks. The state had passed a series of laws to protect maritime heritage, starting with the Museum Act of 1959 and amended in 1964, followed by the Museum Act of 1969 and the Maritime Archaeology Act of 1973. These laws declared that ancient wrecks, including the Vergulda Draak and their maritime archaeological sites, belonged to the Western Australian Museum on behalf of the Crown. They prohibited unauthorised salvage, criminalised interference with wreck sites, and, crucially, offered no compensation to finders like Robinson. The state's argument was clear. Historic wrecks were public heritage, not private bounty, and needed protection from looting to preserve their scientific and cultural value. Tensions escalated when the Museum Board took control of the Vergulda Draak site. They barred Robinson from further salvage and seized artefacts he'd recovered, including those he'd handed over in good faith, without paying him a cent. For Robinson, this was a double blow. Not only was his livelihood as a salvor threatened, but he felt the state was unfairly stripping him of his hard-earned fines. By 1974, frustrated and financially strained, Robinson took his fight to the High Court of Australia. He sought declarations that Western Australia's laws were invalid on 3 grounds. First, they were extraterritorial, as the wreck lay beyond state boundaries on the seabed. Second, they were repugnant to the Imperial Merchant Shipping Act of 1894, which dealt with wreck ownership and salvage. And third, they conflicted with Commonwealth laws like the Navigation Act of 1912 and the Seas and Submerged Lands Act of 1973, which asserted federal control over offshore areas. Western Australia responded with what's called a demurrer, a legal manoeuvre to dismiss Robinson's claim without a full trial, arguing it had no merit. The Commonwealth and other states, New South Wales, Victoria, Queensland and Tasmania, intervened, recognising the case's implications for federal state power over offshore resources. What began as one diver's quest for treasure had snowballed into a constitutional battle pitting individual rights against state heritage protection and federal authority. This set the stage for the High Court to wrestle with complex questions of law, jurisdiction, and heritage that we'll explore next. Coming up, the High Court of Australia considers Alan Robinson's bid to claim his treasure. This wasn't just about a diver and his treasure. It raised thorny constitutional questions that tested the boundaries of state power, federal authority, and individual rights. Alan Robinson challenged Western Australia's laws, the Museum Act of 1959, Museum Act of 1969, and Maritime Archaeology Act 1973, which vested the Vergulda Drake's wreck in the Western Australian Museum and blocked his salvage efforts. His arguments, and the state's defence, revolved around 4 key legal issues. First, standing. Did Robinson even have the right to sue? To challenge state laws in the High Court, a plaintiff needs a special interest or a private right affected more than the general public. Robinson argued he qualified as the wreck's finder with a potential salvage reward under the Federal Navigation Act of 1912. But the majority of the court, Justices Barwick, Gibbs, Mason, Jacobs and Stephen, ruled that his interest was too speculative. He had discovered the wreck, yes, but there was no guaranteed salvage entitlement under law. Only Justice Murphy thought this investment of time and money gave him enough of a stake. On this threshold point, Robinson stumbled. He was found to have no standing. Second, there was state legislative power. Could Western Australia regulate a wreck lying beyond the low water mark in Commonwealth-controlled territorial waters? Robinson claimed the state's laws were extraterritorial and invalid, as the Vergulda Drake lay outside state boundaries. Justices Gibbs and Mason countered that states could legislate offshore if there was a sufficient connection to state interests. Here, the preservation of maritime heritage. Justices Murphy and Barwick disagreed, calling the wreck's location outside state waters a fatal problem. The judges were split, leaving the scope of state power offshore unresolved. Third, the challenge of repugnancy to imperial law. Robinson argued that Western Australia's statutes clashed with the Merchant Shipping Act of 1894, which governed wrecks and vested unclaimed ones in the Crown. The court gave this argument little weight. Justice Gibbs treated the Crown in this context as the state crown in right of Western Australia. Justice Mason doubted the 1894 Act applied to wrecks lying offshore, and only Justice Murphy was prepared to view the state laws as undermining traditional salvage principles. The issue was raised, but did not drive the outcome. The fourth thing to consider was inconsistency with Commonwealth law. Under Section 109 of the Constitution, state laws are invalid if they clash with federal laws. Robinson argued Western Australia's laws conflicted with the Navigation Act of 1912, which covers salvage, and the Seas and Submerged Lands Act of 1973, which asserts Commonwealth seabed control. Both Justices Mason and Gibbs saw no inconsistency, reasoning that the state laws focused on heritage protection, not navigation. But Justices Jacobs and Murphy saw at least partial conflict, especially in provisions criminalising salvage or disturbing wreck sites, which could undermine federal salvage rights. Again, the court was divided. Robinson cast himself as a pioneer, defending individual enterprise against state overreach. Western Australia emphasised cultural heritage, arguing that private salvage risked the loss of irreplaceable history. With the Commonwealth and other states intervening, the case became a high-profile test of Australia's federal balance. In the end, Robinson lost. The majority held that he lacked standing, and no clear majority emerged to strike down the state legislation. The wreck and its artefacts remained vested in the WA Museum, and the law soon moved on. Commonwealth heritage protections under the Historic Shipwrecks Act of 1976 overtook the constitutional skirmish. So, how did the High Court resolve this tangle of issues? In the end, Robinson lost at the very first hurdle. The majority concluded he had no standing, no sufficient legal interest to challenge the Western Australian laws. Without standing, his case could not proceed, and Western Australia's demurrer succeeded. The court did not strike down any part of the legislation, though along the way the judges split sharply on the deeper constitutional questions. The debate over standing was fierce. Robinson argued that as the wreck's finder, with years of effort and money sunk into the search, he had more than a speculative interest. But Justice Barwick gave this summary to the High Court on the 31st of August 1977. The plaintiff is not merely in the position of a member of the public who falls within the prohibition of the statute. The Solicitor General for Western Australia, in a somewhat colourful expression, suggested that the plaintiff had no greater interest than a weekend picnicker who happened to drop upon the wreck during his weekend leisure. But it seems to me that such a proposition is untenable. The contrast between the position of the plaintiff and that of the Solicitor General's artless wanderer is so stark as to be eloquent of the plaintiff's peculiar interest in the operation and validity of the acts. It is no exaggeration to say that no member of the public is affected to the same extent as is the plaintiff by the provisions of the acts to which I have referred. I conclude that the plaintiff has a sufficient interest to maintain his suit. Despite this recognition of Robinson's unusual position, Justice Barwick ultimately joined Gibbs, Mason, Jacobs, and Stephen in holding that his supposed salvage rights were too uncertain to give him a legally enforceable interest. Only Justice Murphy dissented, insisting Robinson had put enough skin in the game to deserve his day in court. On the broader constitutional issues, the court fractured again. Justices Gibbs and Mason accepted that Western Australia could legislate offshore if there was a sufficient connection to state interests like heritage protection. But Justices Barwick and Murphy were unconvinced. Justice Barwick dismissed WA's appeal to history. he told the High Court. Some endeavour was sought to be made to establish the proposition that, because of the historical significance of these wrecks to the peace, order and good government of Western Australia, the acts were laws for the peace, order and good government of Western Australia. I find this endeavour completely unconvincing. After all, these wrecks, but particularly the Gilt Dragon, were wrecks of Dutch ships which were in the course of commerce between Holland and the East Indies. They were not even bent upon or in any wise instrumental in the exploration of the Australian coastline. Less, indeed, were they engaged in doing anything with particular historical significance for the colony of Western Australia. He went further. The most that can be said about them is that they rest on the bed of the sea off the northwestern coast of Australia, and that the coastline of that coast now forms the boundary of Western Australia. By no stretch of the imagination could it be said that the declaration of marine archaeological sites or of ancient wrecks on the bed of the sea off the coast of Western Australia was really a matter of concern for the peace, order and good government of the state of Western Australia. Despite his rhetoric, the court never reached a binding majority to strike the WA laws down. Robinson walked away empty-handed. The artefacts and rights to the Vergulda Draak remained vested in the Western Australian Museum. The grand constitutional battle ended, not with treasure for the finder, but with the High Court shutting the door on his claim before it really began. This case wasn't just about one diver. It reshaped Australian law, heritage management and federalism in profound ways. Firstly, the outcome. Robinson ultimately lost on standing 5-1, meaning he could not maintain his claim in the High Court. However, in the course of the judgment, several judges exposed serious problems in Western Australia's legislation. Some provisions overreached and clashed with Commonwealth law, highlighting inconsistencies that made parts of the state's regime vulnerable to invalidity. The Historic Shipwrecks Act of 1976 was introduced and proclaimed in 1977, creating a national framework to protect wrecks in Commonwealth waters. It countered treasure hunting and promoted scientific archaeology. Today, it safeguards more than 8,000 registered sites, including the Vergulda Draak, and requires permits for disturbance. The legislation embodies the principle that maritime heritage is a public good, aligning with international norms while ensuring that historically significant artefacts are preserved. Finally, it had many cultural and societal ripple effects. Robinson professionalised maritime archaeology in Australia. It marked a major shift from private salvage to regulated heritage preservation, sparking debate about whether history belongs to finders or the public. The case encouraged collaborations between museums, governments, and divers, inspiring public engagement through exhibitions and tourism. More broadly, it helped establish a standard that cultural heritage is a public good, foreshadowing principles later enshrined in the UNESCO 2001 Convention on the Protection of the Underwater Cultural Heritage. In essence, Robinson versus Western Australian Museum transformed a personal dispute into a cornerstone of Australian law, ensuring that the treasures of our seas serve education and preservation rather than private gain. Its legacy endures in every protected wreck and clarified jurisdiction. Thanks for listening to Crime Insider's Judgments. We love hearing your feedback, so please rate and review this episode. If you have a case you want us to cover, let us know via Instagram at Listener Crime or TikTok at Listener Crime Team. I'll be back again next Thursday with another case. I'm Dan Mullins, with sound designed by Niall Fernandez. This series was recorded and produced on Gadigal land.